Template for Prosecution, Part 1. April 9, 2021 by Anna von Reitz. Among the many things we have learned is that the clerk is the one responsible for the misadministration of the courts. Not the judges. Not the attorneys. Most clerks are ignorant and do things by rote. They rely upon advice from state attorney generals, most of whom are also ignorant and doing things by rote, because that's the way we've always done it. At each step and each role within the court system there is significant compartmentalization, which serves to ensure continued ignorance and misadministration. The situation in Alaska described in our public corrective notice and demand may seem to be peculiar to us and to our state, but, however distinct each state's circumstance is, we can assure you that fundamentally similar fraud schemes and similar misadministration of justice has occurred in every state of the Union. To address these travesties and ignorances, we have adopted both a top-down and a bottom-up strategy, which explains why our response nearly always involves two separate actions: one to intervene and stop the immediate trespass, one to bring long-term correction and relief. The first action is always brought at the level of the court imposing upon a victim of the double-ended impersonation scheme our employees have contrived to fleece their employers. This is almost always an action addressing the court clerk in their capacity as the General Sessions Clerk, and involves a municipal citizen operated in the name of the victim. The second action is brought in the United States District Court for your state. This action is the systemic correction, the top-down part of the solution, in which the Article I administrative court is invoked to provide discipline for the erring local and state-of-state franchise courts, and to provide damages as relief for the victims. You might think that the sequence should be reversed, and that the second action should come first, and indeed, in real life, both actions have to be pursued in tandem. Typically, as the first court is inflicting the damage, the second court has to be invoked after the damage, but in a practical sense, the moment that you are trespassed upon by your wrong-headed and misdirected employees, damage has occurred, and you have the basis to present your initial claim of trespass to the United States District Court. We have found that a timely and brief and properly worded filing in the United States District Court is often sufficient to magically erase lower franchise court cases. They simply disappear, never to be heard about again. When an improper action has actually gone to trial and rendered a verdict on the record, these same cases show up as having been exonerated, dropped after the fact, with damages paid to the victim. Our work as the actual civilian government of this country is to protect our people and their assets from illegal search, seizure, confiscation, attachment, arrest, detainment, and subjection under foreign law. So, the place to start your countermeasures in response to trespasses against you and assets, is with your actual government, your state assembly. Go to www.theamericanstatesassembly.net, and if you have not declared and officially adopted your birthright political status, do so now, hopefully before you are misaddressed by one of these foreign courts. When a trespass against you or your property occurs, there is a Federation form called Criminal Incident Report, available online from our websites and from your state assemblies. Fill it out. Then have your state recording secretary record it. This establishes an international record that is admissible in international courts. Then you will have to go to uscourts.gov and look up two possible cover sheet forms, A091 and A0442, and decide which one best applies to your situation. Fill the appropriate form out, slap it on top of a copy of your recorded criminal incident report, and file the package with the United States District Court for your state. This identifies the jurisdiction, land, in which the trespass occurred, and establishes your credibility as a landsman or woman who is bringing the objection and damages claim before the district court. Going through your state assembly and following this simple procedure makes it much more difficult for them to misunderstand the context of the claim or ignore the information. Important point to remember: judges are extremely busy and need to have information crunched down to the essentials if they are to make prompt and correct decisions. You want service from them, so give them what they need, and when you write your criminal incident report, don't get lost in insignificant detail or wander around in legal theory land or rant about constitutional rights. It will be apparent from your paperwork that you are an American and you are claiming your constitutional guarantees. Likewise, the judge doesn't need to know that the incident occurred at 9 o'clock on Sunday, the 17th of April, 2020, and your car was facing southeast at the intersection of Rainier and Bluff Street in Pleasantville, New York, when the judge needs to know that you were arrested and detained against your will by the Pleasantville Police Department, that you were thrown face down on the pavement and your arm was broken for no apparent or stated cause, and you were severely damaged emotionally and physically. Cut to the chase. If the judge has questions, he'll ask them. Present the bill from your doctor, a photograph of your broken car window, the bill from the auto glass company to replace it, and a copy of any sworn witness testimony as part of your package. Make it as cut and dried as you can. Ask for discipline and correction of the offending police department and officers. If you live in Pleasantville or have to travel there frequently, ask for a protective order to prevent any further incidents of this kind. Ask for damages equal to 3 times your actual billed costs, and a reasonable but stiff assessment as damages for your pain, suffering, fear for your life, and continuing discomfort. Such intangibles are hard to assess, so the law allows us to assess them within reason. $100,000 up to $2 million for such an incident, depending on contributing circumstances, would not be unreasonable, but there is no point in asking for $150 billion no matter how upset you are. God gave us common sense. Use it. Keep in mind that the district court is responsible for abuses committed by district personnel, and that includes incorporated state workers and incorporated county employees, and the personnel of subcontractors, like the Pleasantville Police Department. Even though they don't appear to be federal employees, they are, by virtue of incorporation and contract. The judge knows this, but you need to know it, too, and be ready to say so. Intervention at the bottom-up level of an ongoing county or state court case prosecution is a considerably more difficult and varied proposition. The aim of these actions is most often to secure the release of people and assets that have been unlawfully seized and impounded, often using unsigned non-judicial warrants. We will take these issues up in Part 2.